Governor Luis Raymund F. Villafuerte vs. Jesse M. Robredo. GR number 195390. December 10, 2014. Facts. In 1995, the Commission on Audit conducted an examination and audit on the manner the local government units utilized their internal revenue allotment for the calendar years 1993 to 1994. The examination yielded an official report showing that a substantial portion of the 20% development fund of some LGUs was not actually utilized for development projects but was diverted to expenses properly chargeable against the maintenance and other operating expenses, in stark violation of Section 287 of RA number 7160, otherwise known as the Local Government Code of 1991. December 14, 1995, the DILG issued MC number 95-216, enumerating the policies and guidelines on the utilization of the development fund component of the IRA. It likewise carried a reminder to LGUs of the strict mandate to ensure that public funds, like the 20% development fund, shall be spent judiciously and only for the very purpose or purposes for which such funds are intended. On September 20, 2005, then DILG Secretary Angelo T. Reyes and Department of Budget and Management Secretary Romulo L. Neri issued Joint MC No. 1, Series of 2005. Pertaining to the guidelines on the appropriation and utilization of the 20% of the IRA for development projects, which aims to enhance accountability of the LGUs in undertaking development projects. The said memorandum circular underscored that the 20% of the IRA intended for development projects should be utilized for social development, economic development, and environmental management. On August 31, 2010, the respondent, in his capacity as DILG Secretary, issued the assailed MC No. 2010-83, entitled Full Disclosure of Local Budget and Finances, and Bids and Public Offerings, which aims to promote good governance through enhanced transparency and accountability of LGUs. Issues: whether or not the assailed memorandum circulars violate the principles of local and fiscal autonomy enshrined in the Constitution and the LGC. Ruling: the assailed memorandum circulars do not transgress the local and fiscal autonomy granted to LGUs. The Constitution has expressly adopted the policy of ensuring the autonomy of LGUs. To highlight its significance, the entire Article X of the Constitution was devoted to laying down the bedrock upon which this policy is anchored. It is also pursuant to the mandate of the Constitution of enhancing local autonomy that the LGC was enacted. Section 2 thereof was a reiteration of the state policy. It reads, thus. Section 2. Declaration of Policy. A. It is hereby declared the policy of the state that the territorial and political subdivisions of the state shall enjoy genuine and meaningful local autonomy to enable them to attain their fullest development as self-reliant communities and make them more effective partners in the attainment of national goals. Toward this end, the state shall provide for a more responsive and accountable local government structure instituted through a system of decentralization whereby local government units shall be given more powers, authority, responsibilities, and resources. The process of decentralization shall proceed from the national government to the local government units. Verily, local autonomy means a more responsive and accountable local government structure instituted through a system of decentralization. In Limbanavi Mang Ellen, the court elaborated on the concept of decentralization, thus. Autonomy is either decentralization of administration or decentralization of power. There is decentralization of administration when the central government delegates administrative powers to political subdivisions in order to broaden the base of government power and in the process to make local governments more responsive and accountable, and ensure their fullest development as self-reliant communities and make them more effective partners in the pursuit of national development and social progress. At the same time, It relieves the central government of the burden of managing local affairs and enables it to concentrate on national concerns. Decentralization of power, on the other hand, involves an abdication of political power in the favor of local governments units declared to be autonomous. In that case, the autonomous government is free to chart its own destiny and shape its future with minimum intervention from central authorities. To safeguard the state policy on local autonomy, the Constitution confines the power of the President over LGUs to mere supervision. The President exercises general supervision over them, but only to ensure that local affairs are administered according to law. He has no control over their acts in the sense that he can substitute their judgments with his own. At any rate, LGUs must be reminded that the local autonomy granted to them does not completely sever them from the national government or turn them into impenetrable states. Autonomy does not make local governments sovereign within the state. Thus, notwithstanding the local fiscal autonomy being enjoyed by LGUs, they are still under the supervision of the President and may be held accountable for malfeasance or violations of existing laws. Supervision is not incompatible with discipline. And the power to discipline and ensure that the laws be faithfully executed must be construed to authorize the President to order an investigation of the act or conduct of local officials when in his opinion the good of the public service so requires. A scrutiny of the contents of the mentioned issuances shows that they do not, in any manner, violate the fiscal autonomy of LGUs. To be clear, fiscal autonomy means that local governments have the power to create their own sources of revenue in addition to their equitable share in the national taxes released by the national government, as well as the power to allocate their resources in accordance with their own priorities. It extends to the preparation of their budgets, and local officials in turn have to work within the constraints thereof. It is inconceivable, however, how the publication of budgets, expenditures, contracts and loans and procurement plans of LGUs required in the assailed issuances could have infringed on the local fiscal autonomy of LGUs. Firstly, the issuances do not interfere with the discretion of the LGUs in the specification of their priority projects and the allocation of their budgets. The posting requirements are mere transparency measures which do not at all hurt the manner by which LGUs decide the utilization and allocation of their funds. Principles. Thus, notwithstanding the local fiscal autonomy being enjoyed by LGUs, they are still under the supervision of the President and may be held accountable for malfeasance or violations of existing laws. Supervision is not incompatible with discipline. And the power to discipline and ensure that the laws be faithfully executed must be construed to authorize the President to order an investigation of the act or conduct of local officials when in his opinion the good of the public service so requires.